William Inman declined to testify on his own behalf Thursday in Ross County Common Pleas Court. Defense attorney Andrew Stevenson also requested a mistrial twice, which were both overruled by Hocking County Judge John Wallace. Jurors will begin deliberating Monday after both sides present their closing arguments. This is Gretchen Gregory with the Logan Daily News.
Your testimony will be treated as a testimony of any other witness. Do you understand all that?
Yes, Your Honor.
All right. And at this point, from speaking to your attorney here a moment ago, it appears that you do not have plans to take a stand. Is that correct?
Yes, Your Honor. I'm declining to take a stand.
All right. And that you reached that decision after a lot of consultation with your attorney, correct?
Correct.
All right. And you imagine that you listened very carefully to their advice and whatever strategy you have in the case, and you decided, based on your conversation with him, that that's the best course for you. Is that correct?
Yes, Your Honor.
All right. Anything else in regard to this from the state?
No, Your Honor.
All right. Anything else from the defense?
We have one last issue, Your Honor.
Yes.
I did take exception with Mr. Scarcella's supposition to Ms. Slapper, who was on the stand, concerning we could have had it tested. I feel that that was an extremely improper statement. I think my tonality at the bench made it clear my opinions regarding that. However, to suggest that we could have had it tested directly attempts to shift the burden of proof to present evidence to the defense, which, if anyone was here from my voir dire, is pretty clear that's not the case. Based on that, I'm going to request, in order, three things. One, a mistrial. Two, I'm going to request a stern reading or reminding from the court and its jury instructions on that point. And alternatively, third, some latitude in my closing argument to address that point. Thank you.
Mr. Scarcella?
Yeah, I don't believe there was anything that happened that would warrant a mistrial at this point in time.
I would agree.
Second of all, you know, the jury instructions, and they are very clear throughout the jury instructions that the state of Ohio alone, who has the burden of proof in this case. I don't believe there's any additional instruction that needs to be provided, both from voir dire through opening, and as both Mr. Stevenson and I addressed in voir dire, as both Mr. Stevenson and Ms. Featheroff addressed in opening, and as I'm sure both Mr. Stevenson and myself in closing will address, it is the state of Ohio that has the burden of proof. I don't believe there's any additional instruction that needs to be done. And as far as latitude goes, it was closing argument. It is argument. Mr. Stevenson can argue whatever points he feels appropriate. I can't imagine myself objecting in closing argument. I've only done it once in my career, and that was in a rape case where the situation was completely and utterly different. I can't imagine anything coming out of Mr. Stevenson's mouth that would warrant me objecting during closing argument. So as far as latitude goes, I don't see any reason why any special latitude need be given.
If you decline the mistrial, decline to give an instruction, I understand what Mr. Scarcella said, and I will deal with it